Good morning, everyone. As my accent betrays, I'm based in Singapore. So I will be giving this inaugural lecture in Singlish. I know there's at least one person in the room that will appreciate that. It is not only an honor, but also a pleasure for me to address you today. I want to thank very much Professor Daudet, the president of the Curatorium, the Secretary General Jean-Marc Touvenin, and all of the staff of the Secretariat and the members of the Curatorium for the opportunity to speak to you today on a subject which has defined my professional career for longer than I like to think, ever since I started practicing as a junior associate in a New York law firm in 1979. The topic is the practice of international law, and I stress the word practice because I stand before you not as an academic, nor as a member of a government department or ministry or attorney general's chambers that negotiates international agreements or advises its stakeholders on matters of international law. Rather, I am a practitioner. I work in a law firm. I've practiced in New York, London, Paris, and now Singapore for some 40 years. And my work in public international law has involved engagement in contentious matters, for example, before the court or the Hamburg Tribunal or the Iran-US Claims Tribunal, and state-to-state arbitrations and investment arbitrations, as well as advisory work, non-contentious work for governments and multinational companies affected by issues of international law. And I'm therefore this morning going to focus on some of the practical aspects relating to international law, leaving the theory and substance of the law to others. You're fortunate, however, that you will have the benefit of one of the world's truly great academics and practitioners in public international law for the general course. And I'm speaking, of course, of Professor Alain Pellet. He's probably, aside from his scholarly and academic activities, has probably made more appearances before the International Court of Justice than anyone in the world. And that's been a source of inspiration, challenge, and dare I say, even fun for me, since we've worked both together and as adversaries in numerous cases, fortunately more together than against each other. But time will tell. Now, I don't think a lecture entitled The Practice of International Law would have gained much traction had it been offered 40 years ago when I was starting out. In the late 1970s, when I embarked down this road, there were very few opportunities to become involved in public international law, particularly as a practitioner. The International Court of Justice had practically no cases before it. There was no United Nations Convention on the Law of the Sea, and thus no International Tribunal for the Law of the Sea, or Annex 7 arbitration, no investor-state arbitration, no Iran-United States Claims Tribunal, no International Criminal Tribunal, no tribunals for the former Yugoslavia, Rwanda, or others, no World Trade Organization, and very few state-to-state ad hoc arbitrations. I might as well have gone home at the time. And by the same token, there were a number of the areas of law that you now hear a lot about today were in their infancy in terms of the applicable legal principles and rules. For example, the law of maritime delimitation was not well developed. We had the 1969 North Sea Continental Shelf cases, the 1977 Anglo-French arbitration, and a bit of state practice, but not much else. What was the appropriate methodology for applying equitable principles, particularly after the International Court of Justice in 1982 in the Tunisia-Libya case indicated that the equidistance method had no privileged status and it did not even have to be used as a first step in the delimitation process? Of course, at that time, the 200 nautical mile exclusive economic zone did not exist as a matter of customary or conventional international law. And the definition of the limits of the continental shelf reflected in the 1958 Geneva Convention was unsatisfactory. Being based on a 200-mile depth criterion coupled with a flexible notion of exploitability, the law provided no fixed limits or certainty. Now, although the 1982 Law of the Sea Convention clarified the limits of the territorial sea, the EEZ, and the continental shelf for a coastal state, including providing for a procedure before the Commission on the Limits of the Continental Shelf, the CLCS, for delineating the limits of the shelf beyond 200 nautical miles, it did not add much clarity to the principles and rules of maritime delimitation. Articles 74 and 83 of the Convention simply refer to international law and the aim of achieving an equitable solution. As for the court's jurisprudence at the time, it revolved around what was termed the Equitable Principles Relevant Circumstances Rule for the delimitation of maritime areas lying beyond the territorial sea. And unlike with respect to Article 15 of the Convention dealing with the delimitation of the territorial sea, which involved application of the equidistance Special Circumstances Rule, there was no suggestion when it came to the EEZ or continental shelf that any particular method of delimitation had an a priori status. It was only in 2001 and 2002, with the court's decisions in the Qatar, Bahrain, and Cameroon, Nigeria cases, that the principles and rules of international law relating to delimitation began to take firmer shape. By indicating that the rules for the delimitation of the shelf were similar to those and closely related to those applicable to the delimitation of the territorial sea, that set the stage for what has by now become the well-known three-step process for the delimitation of maritime areas. First, the calculation of a provisional equidistance line, although identifying the base points from which to calculate that line can sometimes be contentious and problematic. Second, identifying whether there are any relevant circumstances characterizing the area to be delimited that call or justify an adjustment being made to the provisional equidistance line. And third, applying the proportionality test, or as it's sometimes now called, the non-disproportionality test, to assess whether the line resulting from the application of the first two steps produces a result that is not grossly disproportionate. Other areas of the law had also not reached the level of maturity that they possess today. To name just a few, international environmental law, including the doctrine of prevention of cross-boundary environmental harm, and the precautionary principle were just coming into focus. The ILC did not adopt its draft articles on state responsibility until 2001. Human rights did not attract a great deal of attention, at least on the legal plane and from a practitioner standpoint. And international watercourse law was slow to evolve. It's true that as early as 1966, we had the Helsinki rules on the use of the waters of international rivers, and these were then superseded by the Berlin rules adopted by the ILA in 2004. But the 1997 United Nations Convention on the Law of the Non-Navigational Uses of International Watercourses, which resulted from 23 years of preparatory work by the International Law Commission, only came into force in 2014 with its 35th ratification. If we turn to the field of investment protection, which has now become a fruitful source of work for practitioners, until the 1980s, private investors who encountered state interference with their investments generally had to resort to diplomatic protection or the espousal of their claims by their home state. In the light of the principle of sovereign immunity, they had little chance successfully to litigate directly against the host state. On matters of substance, the legal consequences of nationalization and expropriation were the subject of extensive debate in the late 1970s and early 1980s. Based on the famous and oft-cited Chortso factory case, a number of questions arose. Was there a practical difference between so-called lawful expropriations and unlawful expropriations? Were large-scale nationalizations of critical sectors of the economy to be treated differently than discrete expropriations? What were the proper standards and methodologies for assessing compensation, and who, outside of economists, had ever heard of discounted cash flow methodology, DCF, or understood how it worked? What was the proper balance between the right of a state to legislate in the public interest and the legitimate expectations of investors who had made their investments based on a pre-existing domestic legal regime that was changing and sometimes radically so? I could go on, but I think you get the picture. And international courts and tribunals still face many of the same issues, but they do so with the benefit of knowledge acquired from a body of arbitral proceedings that did not exist 40 years ago when I started out. At this spring's American Society meeting, the theme of which, perhaps not coincidentally, was international law in practice, Sir Christopher Greenwood, a former judge on the court, recounted that when he opened the ICJ reports, the court's reports for the year 1977, a year when he too was embarking on his distinguished career, that volume of the reports consisted of 4 pages, 2 in French, 2 in English. It also had a note indicating that the volume contained no index or table of contents. It's a little difficult when you have 4 pages, under which somebody had written in Judge Greenwood's volume, nor anything else. How the landscape has changed. And while the relevance of international law in today's political climate may spark cynicism in some quarters, opportunities that I never dreamed existed all those years ago now abound for you. If you look at the list of pending cases before the ICJ, there are 14 such cases, 13 of which are active. The subject matter of those cases covers a wide spectrum of issues under international law, ranging from maritime delimitation and the delimitation of the continental shelf beyond 200 nautical miles, disputes over the validity of prior arbitral awards, the obligation to negotiate matters related to a state's claimed access to the sea, the application and interpretation of the conventions on the suppression of financing of terrorism and the elimination of all forms of racial discrimination, claims relating to alleged violation of maritime spaces, the question of immunities in criminal proceedings against a government official, the Vienna Convention on Consular Relations, status and use of river courses, a request for an advisory opinion on the legal consequences of the separation of the Chagos Archipelago from Mauritius, and until they were discontinued just last month, 2 cases concerning a request to revise and interpret a judgment rendered by the court in 2008. And in short, the court has never been busier. And I think it will be a long time before we see another volume of the ICJ reports that matches that of 1977. And I would suggest that if you cannot identify any issues of public international law that interest you in that roster of cases, I respectfully suggest that you may be in the wrong place this morning. In Hamburg, the International Tribunal for the Law of the Sea has also seen an expansion of its case law, and equally significant, the types of cases and the types of issues that come before it. 10 of the first 15 cases addressed by ITLOS were prompt release cases. But the tribunal had also had occasion to order provisional measures pending the constitution of Annex 7 tribunals in 6 cases: the Southern Bluefish Tuna case, Mox Plant, the land reclamation case between Malaysia and Singapore, ARA Libertad, the Arctic Sunrise case, and the pending Enrique Lexi case between Italy and India. And more recently, ITLOS has decided 2 maritime delimitation cases. It was dying to have a delimitation case, which seemed to be the exclusive prerogative of the court. And it finally got not 1, but 2, the Bangladesh-Myanmar and the Ghana-Côte d'Ivoire cases, including the first case concerning the delimitation of the outer continental shelf beyond 200 miles, where again, for the first time in judicial proceedings, a gray zone was established, a maritime area in which one state had sovereign rights over the column of water and the other state had sovereign rights over the seabed and subsoil. Now, significantly for potential users of the Hamburg Tribunal who are looking for predictability, both the full tribunal in the Bangladesh-Myanmar case and the special chamber in the Côte d'Ivoire-Ghana case adhered to the basic principles of delimitation previously articulated by the ICJ. And I'd note in passing that Annex 7 tribunals constituted under the United Nations Convention have also largely relied on the court's jurisprudence for maritime delimitation. Now, interestingly, both cases decided by ITLOS, both maritime delimitation cases, were instituted as Annex 7 proceedings under the default provisions of Article 297 of the Convention. But in each case, however, the parties subsequently agreed to transfer the cases to ITLOS. In the Bangladesh-Myanmar case, they were transferred to the full 21-judge tribunal, and in the Ghana-Côte d'Ivoire case to a special chamber comprised of 5 judges. And my impression is that the parties to those cases did so primarily, not exclusively, but primarily out of consideration for costs and logistics, because when a case is submitted to Annex 7 arbitration, which is essentially a kind of ad hoc arbitration, the parties are responsible not only for the selection of arbitrators and the entity that will administer the arbitration, but they have to pay for them. And in contrast, the Hamburg Tribunal, just as the International Court, comprises sitting judges, experienced registries, and excellent facilities that come at no cost to the parties. If we turn to the other institution that shares the Peace Palace with the court, the Permanent Court of Arbitration, it's quite remarkable to think of this, but in 1980, it was engaged in no cases. Fast forward to today. I was reading the 2016 annual report of the PCA just last week. The 2017 report came out, but I haven't looked at it. But if you base yourself on the 2016 statistics, the PCA is currently acting as registry in 4 state-to-state arbitrations, 84 investor-state arbitrations, and 46 other arbitrations under contracts to which one party is a state or state-controlled entity or international organization. Consider the number of lawyers and arbitrators, not to mention registry staff, that's keeping busy. Now, as I noted earlier, the proliferation of investor-state arbitration over the past 20 years has provided fertile ground for lawyers, practicing lawyers, to become involved in cases having an international law dimension. Investment arbitration usually gives rise to numerous public international law issues. The standing of private investors to bring treaty and sometimes even contract claims directly against a state, the interpretation and application of bilateral investment treaties or multilateral trade agreements, the attribution of acts of a state-owned entity to the state itself, with respect to which investment tribunals frequently refer to Articles 4, 5, and 8 of the Articles on State Responsibility. The balancing between a state's prerogative to legislate or regulate in the public interest and the legitimate expectations of foreign investors, including the doctrine of necessity, and the standards and methodology for assessing compensation for expropriation or breach of fair and equitable treatment, and the meaning and scope of most favored nation clauses. That's just to name a few of the kind of issues that can arise in investor-state arbitration that touch on matters of public international law. But that wasn't the case in the 1970s. Take the well-known Barcelona traction case that was decided by the court in 1970. One of the principal issues in that case was whether Belgium had standing to espouse the interests of its nationals who were shareholders in a Canadian company, the Barcelona Traction Light and Power Company, against Spain for actions taken by the latter, taken by Spain, that seriously prejudiced the financial viability of the company. And the court, in its judgment, rejected Belgium's claim. It noted that a wrong done to a company frequently causes prejudice to its shareholders, but that fact does not imply that both are entitled to claim compensation. And as the court explained, and if I quote from the 1970 judgment, whenever a shareholder's interests are harmed by an act done to the company, it is to the latter, the company, that he must look to institute appropriate action. For although two separate entities may have suffered the same wrong, it is only the one entity, the company, whose rights have been infringed. Now, the conclusion of what, as of today, amount to over 3,000 bilateral investment treaties and multilateral trade agreements has fundamentally changed the dynamic. In short, private individuals and companies now often have a legal basis on which to bring claims directly against a state for alleged violations of fair and equitable treatment, discrimination, obligations to provide full protection and security, denial of justice, frustration of legitimate expectations, and expropriation. Now, it must be said that even at the time the court rendered its judgment in Barcelona Traction, which was just 4 years after the Washington, or ICSID, Convention had entered into force, the court drew attention to the fact that the international legal scene was changing. And if I can quote once more from the court's judgment in 1970, it observed, indeed, whether in the form of multilateral or bilateral treaties between states, or in that of agreements between states and companies, there has, since the Second World War, been considerable development in the protection of foreign investments. The instruments in question contain provisions as to jurisdiction and procedure in case of disputes concerning the treatment of investing companies by the states in which they invest capital. Sometimes companies are themselves vested with a direct right to defend their interests against states through prescribed procedures. So the court all those years ago saw what was coming. And if you look at the statistics of the International Center for the Settlement of ICSID disputes, investment disputes, ICSID, those statistics bear this out. There are currently 153 state parties to the ICSID Convention. The first arbitration registered by ICSID was in 1972. Yet over the next 8 years, between 1972 and 1980, only 9 cases, investor-state cases, were registered by ICSID, an average of about 1 a year. And the period between 1981 and 1996 was also equally lean. The ICSID registered about 29 new cases, which was about 2 a year, and during that 15-year period. And in fact, in 7 of those years, either no cases or just one new case was registered. But since that time, ICSID's case law has expanded exponentially. From 1997 to 2007, 221 new cases were registered, an average of about 22 per year. And from the end of 2008 to 2016, over 300 new cases were registered, with 50 new cases registered in 2012 and 52 in 2014. And by any measure, that's a pretty impressive track record. And that doesn't even include non-ICSID cases that the ICSID Secretariat administers. Now, for those of you who like to look at things from a geographical perspective, about 25% of ICSID cases have involved states from Eastern Europe or Central Asia, 24% from South America, 16% from Sub-Saharan Africa, 10% from North Africa and the Middle East, and 7% respectively for states from Western Europe, South and East Asia and the Pacific, and the North and Central America and Caribbean region. As more and more bilateral investment treaties and multilateral agreements came into force, investors, often with the help of their legal advisors, began to realize that these instruments afforded them a judicial means to institute proceedings directly against a state for breaches of its treaty obligations. And it's now become standard practice in law firms for litigation departments. I'm a litigator, I work in a litigation department, to impress upon our corporate and commercial colleagues the need in structuring international investment projects not simply to take tax considerations into account, but also whether the investment should be channeled through a jurisdiction that has a BIT, a bilateral investment treaty, with the state where the investment will be made. On the other side of the equation, states that suddenly found themselves as respondents in large claims in investment arbitrations were frequently astonished. What had they signed up to in becoming a party to the Washington Convention or concluding a whole slew of bilateral investment treaties, which seemed relatively innocuous at the time they were signed? And I'm not alone with colleagues in having spoken with representatives of states who negotiated many of these treaties in the 1980s and 1990s who can readily confess that they didn't know what they were signing up to. It seemed like a good idea. We now see some states denouncing the Washington Convention or amending their model bilateral investment treaties. And in Europe, the recent decision of the Court of Justice of the European Union in the ACMEA case has cast a shadow over the legality of compromissory clauses in intra-EU BITs. Untitled is currently discussing the establishment of a permanent investment court, which would also envisage an appeal mechanism. And last March, the U.S. Trade Representative acknowledged that the United States wants to opt out of ISDS, Investor-State Dispute Settlement, in NAFTA. And his position sounded very much like a return to the days of state espousal of the claims of private entities. So does this sound the death knell of investment arbitration? I doubt it. With so many bilateral investment treaties and multilateral trade conventions still in force, I believe that investor-state arbitration will continue and will be a fruitful source of work for practitioners and academics and arbitrators. But I sometimes think that with all the goodwill in the world, those who continuously try to improve arbitration rules or treaties themselves risk producing results that are counterproductive in potentially scaring off potential users. Now, the proliferation of investor-state arbitration has also had other knock-on effects on which opinion is divided. One such example is the increasing number of investment claims being brought by private parties who rely on third-party funding, often with the help of their legal advisors. Third-party funding to finance the costs of the arbitration, including legal and expert fees. For their part, third-party funders, who after all are essentially looking for a return on their investment commensurate with the risk that they take, are also becoming more sophisticated. Many of them now employ individuals knowledgeable about investor-state arbitration to assess the prospects of success as part of their due diligence, their decision-making whether to back a particular case. Now, personally, I'm not against third-party funding. It seems to me that a private entity should be able to finance a case as it wishes, using internal funds, borrowings, or other sources. But I would caution that there needs to be increased transparency to avoid potential conflicts between third-party funders and counsel, or even more importantly, between third-party funders and arbitrators. I've experienced one case where the claimant was being financed. This was an investor-state arbitration, where the claimant was being financed by a third-party funder who did not disclose the fact that it did a significant amount of business with the law firm in which the president of the investment tribunal was a partner. And until shortly before the oral hearings in the case, it appears that the president of the tribunal was not aware that a third-party funder was even involved in the case, let alone one that did a significant amount of business with his law firm. But when that news belatedly emerged rather late in the proceedings, the president resigned and the arbitration was thrown into considerable disarray. Then there's the question of non-parties to investment arbitrations requesting the opportunity of submitting amicus briefs, which are also sometimes justified on the grounds of transparency. And here I have to confess, maybe it's my age, that I'm a bit old school. The trend in investment arbitration is undoubtedly towards greater transparency. In contrast to commercial arbitration, investor-state arbitral awards are almost always published, and this has had the positive effect of contributing to a jurisprudence constante with respect to a number of legal issues that arise in investment arbitrations, and I'm in favor of that practice, and it's been useful and healthy. But I'm probably in the minority in not understanding why non-parties to an investment arbitration should be able to poke their noses under the tent by filing amicus briefs unless such briefs can genuinely assist the tribunal due to specialized knowledge of a particular matter. I feel reasonably confident that many contracting states to the Washington Convention did not envisage such a development when they became parties to the convention, any more than they expected third-party amicus submissions, and I want to distinguish amicus submissions from requests for permission to intervene under clearly defined procedures and rules. But I do not believe that most states to the Washington Convention envisaged the possibility of amicus briefs when they entered into that convention. And certainly, the original ICSID arbitration rules did not contain at the time what now appears in Rule 37 regarding the ability of a non-disputing party to file submissions with the tribunal. These are issues you can debate. And even arbitral institutions that have traditionally focused on commercial disputes involving private parties based on municipal laws, the governing law, are not immune to many of these trends. In 2016, the International Court of Arbitration of the ICC saw over 800 new cases filed, of which about 15% involved states or state entities as parties to the arbitral proceedings. And other arbitral institutions, such as the Singapore International Arbitration Center and the London Court for International Arbitration, are also witnessing strong caseload growth. And on top of this, it seems to be popular for more and more countries to want to establish their own arbitration centers with the ability to administer not simply commercial disputes, but also cases involving states or state-owned entities. But will the market sustain that kind of growth? And I'm personally not convinced. It's no accident that the most successful arbitration bodies are those situated in countries where there's a strong respect for the rule of law and an efficient judicial system, which is critical for the recognition and enforcement of arbitral awards. And those institutions are also staffed with competent professionals with sound arbitration administration experience. New institutions, which seem to be popping up almost every month, face the challenges of internal capacity building and the risk of relatively rapid turnover of staff, not to mention having awards where they are the seat of arbitration enforceable in that country. And many arbitration practitioners have started their careers working with arbitration institutions only to be lured away by law firms in order to actually practice what they preach. And arbitral institutions need to be able to handle these situations, which the more mature ones can. But the good news in all this is that it provides fertile ground for the practitioner. What Oscar Schachter once described as the invisible college of international lawyers has now become a much wider and much more visible community. True, when it comes to cases before the International Court of Justice or state-to-state arbitration, one tends to see many of the usual suspects acting as counsel or advocate. But new faces are always welcome, and there's been an increasing diversity in the individuals who both stand at the podium in the Great Hall of Justice or sit on the bench. First woman to sit as a judge on the court was the formidable French professor, I think she was probably Professor Pellé's professor, Suzanne Bastide, who was named by Tunisia as its judge ad hoc in the interpretation and revision proceedings in the Tunisia-Libya case. And she demonstrated her independence by voting with the majority and rejecting Tunisia's revision application. And she was followed by Dame Rosalind Higgins, who was elected to the court in 1995 and became president in 2006. President Higgins brought not only her academic expertise to the bench, but also her experience as a practitioner, who was familiar with the kinds of practical matters that lawyers appearing before the court frequently wrestle with. In 2010, Judge Sway, who was elected vice president of the court this year, and Judge Donahue were elected to the court, and they were followed by Judge Sebutinde in 2012. And there are also 3 female judges on the International Tribunal in Hamburg. Now, the court is the principal judicial organ of the United Nations and applies international law under Article 38 of its statute. And that, together with the composition of the court and the fact that the court, as you heard, has 2 official languages, French and English, presupposes a degree of diversity in the legal traditions that judges bring to the bench. And so, too, does Article 9 of the court statute, which provides that the electors of judges in the General Assembly and the Security Council shall bear in mind that the persons to be elected should not only possess the qualifications required, but I quote, but also that in the body as a whole, the representation of the main forms of civilization and of the principal legal systems of the world should be assured. Now, regrettably, in my opinion, the same cannot be said about the diversity of the individuals who tend to appear before the court, or indeed before ITLOS, and to a somewhat lesser extent before investor state tribunals. as counsel and advocates. Undoubtedly, these are individuals who possess the qualifications required. But in my respectful view, greater gender and geographic diversity would be welcome. And it is a contribution to the practice of international law that all students participating in the academy or sitting in this room can make and should make. But do it seriously. As Mark Twain once remarked, the secret of getting ahead is getting started. But of course, he's also the same person who said, never put off until tomorrow what you can put off until the day after tomorrow. Several years at a workshop we convened in London on issues of international law, a participant asked Professor James Crawford, this was before he was a judge, does that mean I should sit down? Am I being yanked off? I'll try and speed up some. I asked Professor Crawford, how do you get to a position where you can plead before the court? And Judge Crawford's, or Professor Crawford's answer was, you just have to do one. It wasn't a flippant remark. Indeed, the best way to become involved in state-to-state litigation is to work with either a government department that finds itself engaged in a case, or an academic who frequently represents states in such cases, or a practitioner such as a barrister or a lawyer who's part of a team of a firm that handles these kind of matters. And while there aren't very many law firms that deal with state-to-state disputes, many more are involved in investment arbitration, where, as I've said, issues of public international law are very important. But it's important to appreciate that the work of a practitioner is not limited to contentious cases. Much of our work is in an advisory capacity, both for states and increasingly for multinationals. I can give you some examples of the kind of issues that companies, as opposed to states, on which they often seek advice. International sanctions. Obviously, sanctions can fundamentally, or the prospect of sanctions can fundamentally affect business opportunities for companies. International environmental law. Is there a risk of transboundary harm for infrastructure projects that companies may be involved with? Oil and gas activities. I'm old, but some of you may remember the movie Marathon Man, where Dustin Hoffman's being tortured by Sir Laurence Olivier, who's drilling his teeth in a dentist chair, and Sir Laurence keeps asking Hoffman, is it safe? Is it safe? That's the question oil companies ask when they're going to invest in prospective offshore areas where there's no maritime boundary. Is it safe? And these can have important practical implications. In the Ghana Côte d'Ivoire case, there was an oil company that was operating in the middle of a big development, a $5 billion heavily leveraged development for an offshore field which was placed smack in the middle of the disputed area between the Côte d'Ivoire and Ghana. And when those proceedings were instituted, and the Côte d'Ivoire requested provisional measures enjoining all petroleum operations pending the resolution of the case, the share price of that oil company dropped 8%. It's a listed company in the UK, 8% in one day. That gets management's attention. And that gets them to call their lawyers. Environmental law, I've mentioned. Human rights law, obviously there are a lot of instances where companies are facing human rights issues in their foreign operations. And as I mentioned, investment protection. So there are plenty of opportunities out there to pursue a career in international law. I don't have a crystal ball, but my feeling is, apart from the existing kind of disputes that you see, we will have increased focus on access to freshwater resources, hydroelectric power generation of the kind at issue in the Kishan-Ganga arbitration between India and Pakistan, clearly transboundary environmental responsibility, human rights, the delimitation of the shelf beyond 200 miles, and even work in the international area beyond national jurisdiction. I think cybersecurity is going to increasingly take on, obviously, an international dimension, and even things such as regulation of cryptocurrencies will have an international dimension. But there's a need to be realistic. For those of you who feel they can carve out a career devoted exclusively to the practice of public international law, you may be disappointed. As the Nobel Prize laureate Richard Feynman once remarked, the first principle is that you must not fool yourself, but you're the easiest person to fool. The reality is that there are not enough state-to-state disputes to enable one to focus exclusively on that narrow area of practice. I receive a lot of applications from individuals who want to practice, get involved in state-to-state litigation, and it's a worthy goal, but it's not enough. And I tell candidates that they cannot live, at least in a law firm, on public international law alone. When it comes to dispute resolution, they need to have a broader skill set and be willing to become involved in investment and commercial arbitration as well as contentious matters that may involve international law issues. And I also advise individuals interested to try and learn some industry-specific, to acquire some industry-specific knowledge, perhaps in the energy field or the construction field or other sectors that populate international projects. Doesn't mean you have to become an expert in these fields, but it helps to be able to speak the language. And many disputes, particularly in the investor-state arbitration, but also sometimes underlying state-to-state litigation, have their origins in disputes relating to these kind of industries and business, and it's useful to know something about it, to be able to speak the language. So I come to the end, Jean-Marc. It is an exciting time to be involved in international law. It really is a central element of our increasingly globalized world. But let me just offer you, if I may, one final piece of advice, which I sometimes tell lawyers in my own firm, which is always take your work very seriously, but never take yourself too seriously. None of us is irreplaceable. Prima donnas can check their personalities at the door, in my opinion. The practice of international law is stimulating, it's intellectually challenging, but it should also be fun. Now, those who know me know that I'm a big Star Trek fan. So with that overview of some of the practical aspects of the practice of international law, let me leave you with the traditional parting words of the Vulcans. Go forth and prosper. Thank you very much.